A flawless factual argument, no matter how brilliantly constructed, can be instantly destroyed by a single procedural error. The 2019 amendments to the Rules of Civil Procedure replaced flexible guidelines with strict, unforgiving timelines. They were explicitly designed to kill old-school delay tactics. We are going to conduct a forensic audit of a collapsed civil case. We will trace its failure chronologically through the 13 sections of Rule 15. Mastering these hyper-technical traps is no longer optional. It is the only way to survive the modern litigation minefield and pass the bar. Under Section 1, a motion is strictly an application for procedural relief, completely separate from a pleading asserting substantive claims. Asking the court to resolve the merits of a case, like declaring a contract void, through a motion instead of a pleading, is a fatal error. Section 2 establishes the baseline rule. All motions must be in writing. This creates a permanent, reviewable record. The strict exception is for oral motions made in open court or during trial. The judge is mandated to resolve these immediately. Section 3 dictates the mandatory contents. Every motion must explicitly state the specific relief sought and the precise legal grounds supporting it. There is a hidden evidentiary trap here. If the motion relies on any fact not already established in the court record, an affidavit must be attached to prove it. Failing the foundational tests of definition, written form, or evidentiary support instantly reduces a motion to a legally void scrap of paper. The 2019 amendments bifurcate motions based on a single strict criterion, whether they prejudice the rights of the adverse party. Section 4 defines non-litigious motions. These do not prejudice opposing rights and include requests like an alias summons, extensions to file an answer, or postponements. These motions are subject to a 5-day instant resolution rule, and there is an explicit ban on setting them for a hearing. Section 5 defines litigious motions. These are high-stakes requests that do prejudice the adverse party, such as motions to dismiss, motions for summary judgment, or a demur to evidence. This timeline maps the rigid 515 rule for litigious motions. The adverse party has exactly 5 days to oppose, and the court has 15 days to resolve it. There is an absolute prohibition against filing replies or any other submissions after an opposition is filed. This bifurcation completely eliminates the old tactical playbook. Lawyers can no longer keep a motion alive indefinitely through endless rounds of replies. Section 6 removes a lawyer's ability to demand a hearing on a litigious motion. That authority now belongs solely to the judge, who exercises strict discretion on whether a hearing is necessary. A common pitfall is assuming a judge will deny a motion simply because a lawyer omitted a notice of hearing in the draft. Under the amended rules, the court itself issues this notice if a hearing is deemed necessary. Section 7 establishes the absolute jurisdictional threshold. No written motion can be acted upon without verified proof of service. The consequences are fatal. A motion for reconsideration filed without proof of service fails to toll the appeal period, rendering the original judgment final. If the court actually chooses to conduct a hearing, Section 8 designates Friday as the universal motion day. The critical exception to the Friday rule applies only to motions requiring immediate action, such as temporary restraining orders or demolition stays. A litigator's control over a motion evaporates the moment it is filed. Its survival is dictated by the court's calendar and flawless proof of service. Section 9 introduces the omnibus motion rule. A motion attacking a pleading or proceeding must include all available objections. Any objection not included is legally waived. This diagram shows the omnibus rule in action. Omitted objections shatter into dust, but there are 4 indestructible exceptions: lack of subject matter jurisdiction, litis pendentia, res judicata, and prescription. Section 10 applies a strict mechanical requirement. A motion for leave must have the intended pleading physically or electronically attached to be valid. Section 11 dictates that motions are not informal letters. They must follow the exact formatting rules of pleadings, carrying proper captions and formal designations. The counsel's signature is mandatory. It acts as an evidentiary certification and a strict accountability mechanism under Rule 7. A motion containing brilliant legal arguments is instantly voided if it lacks the required structural attachments or a valid signature. Section 12 serves as the ultimate procedural kill list. It expressly bans motions that were previously weaponized for dilatory tactics. The general motion to dismiss is dead. It's restricted to only 4 grounds: lack of subject matter jurisdiction, litis pendentia, res judicata, and the statute of prescription. There is a total, uncompromising ban on motions to hear affirmative defenses, as well as motions for reconsideration of those defenses. Extensions of time are strictly limited. The sole exception allows a single 30-day extension to file an answer. Section 13 applies to expedited proceedings, such as summary procedure, where the rules are aggressively curtailed. The restrictions here are absolute. In a summary procedure context, even res judicata and prescription cannot be used as grounds for a motion to dismiss. Attempting to file a prohibited motion triggers immediate judicial rejection and exposes the attorney to potential disciplinary action. The 2019 amendments replaced the procedural flexibility of the old Rule 15 with a rigid, algorithmic framework built to eliminate delay. There is zero tolerance for missing proofs of service, violated 5-day timelines, or the filing of explicitly prohibited motions. You must shift your mindset from reactive arguing to proactive architectural planning of your procedural moves before ever stepping into court. Precision in drafting and strict adherence to timelines are the only methods to survive the modern courtroom and successfully navigate the bar exam.